Very good evening, councils and one and all present here. So, firstly, welcome, off the record, welcome to the finals and congratulations for making it so far. So, before we begin, I take this opportunity to introduce you all to the bench and make you all more familiar. So, this is Madhukar, who will be the principal judge on the bench, and followed by myself, Naman Makadali. And we have the opportunity to take you through the course. I hope the councils appearing before us are well aware of the rules and regulations of the competition. And I know the nervousness is tickling you all in the tummy. And in this juncture of anxiety and a combination of excitement and anxiety, which is a very rare combination indeed, if the councils, the bench is ready, so do you need 2 minutes or a couple of seconds to organize, or you can start the presentation? Okay. So I hope the speakers are sitting in the order wherein we have the respondent in the middle. Both the sides? No? Okay. At your comfort, and if there is a particular vastu that works good for you, we would respect it. Sir?
Council seeks permission to begin. Naming the law of the bench. If it may please, the council seeks permission to address the bench as a lordship.
Why your lordship? Why not your honor also?
The lordship seems more clear.
No, you have that colonial mindset. No one is ever in this country. Rule of law which rules the entire country. Even the predecessor of this honorable court has clearly said we should shed the colonial mindset and give up to the culture of this country. So start with the due respect is what is expected from the bench. No appeasement is expected.
Yeah.
So we address as your lordship.
Why not your honor? Why not, sir? No. Why?
It was well given in the rules that we have to.
No, which rule says that you should address judges as your lordship? You are not in colonial, you are not really standing before East India crown. This is the democratic setup which is democratically elected by the country of this, and we have an accepted constitution. We abide to the constitution. So we will come to the reality and we will shed our colonial colors.
But we have a justification as to why you want to call us as your lordship.
There is no justification.
Just because it sounds fancy.
Ready? Go.
The council seeks permission to address the bench as your honor. The council is appearing before the honorable court in the matter of Ms. Ahana versus Ms. Shaw on behalf of the appellant under section 96 of the civil procedure.
What 96 is? First of all, satisfy me on the maintainability of this petition.
We will come with the first issue.
Address what bench has.
Yeah.
No. What bench is posing you address those issues.
Yeah. Okay.
What 96 is and how you will fit it under 96. 96 of CPC, what it says.
Any aggrieved party to any decree passed by the subordinate court has conferred.
Which is the subordinate court you appeared before in the trial court?
District court.
How come? What is your prayer before district court?
We are claiming for damages.
Thank you. Have you filed an application to dismiss the issued decree by the lower courts?
No.
Under Order 9 Rule 30?
No, Your Honor.
Why? Without dismissing the decree, how are you even maintaining this?
The district court has already dismissed the. Already dismissed my claim. Therefore, I am appealing.
Dismissed your claim? Can you please enlighten the same set facts under the facts of the case, where it says that the district court has dismissed the facts?
Ms. Ahana through little struggle claiming damages for negligence to the district court, while the court dismissed the petition by stating the little struggle did not owe any duty of care. Therefore, we are here before now. Your Honor, there are three main issues involved in the present case.
So in this case, is it right to understand that Ahana is a consumer? Does she come under the definition of consumer as enshrined in the Consumers Act 2019 amendment?
Yes, Your Honor, she is a consumer.
Then why haven't you approached the consumer court? So can you please help the court in understanding what does section 15 of CPC suggest?
Before we move forward, Your Honor, I am not only here to get my compensation, but also to claim a statutory right. Therefore,
What is your statutory right? Come to, I'm asking you, come to the point.
I'd like to pass on a complaint.
There you are agreed, and what is your statutory right? So that you can pass appropriate orders to address your statutory right.
And why have you not exhausted this remedy in the consumer's court?
My effective remedy was at the district court. Only after exhausting my effective remedy, I have approached
Yeah,
the.
what does section 15 of CPC say?
Every suit shall be instituted in the court of the lowest grade competent to try.
Section 16?
Suits should be instituted where subject matter suitable. Subject to the.
So the council admits that Ms. Ahana is a consumer in this case, and she's an aggrieved consumer. So why have you not? Section 15 clearly says that. One second, don't try to overspeak when the bench is trying to make a question. So when you have agreed to the definition of consumer, and when Ms. Ahana has been an aggrieved consumer, and when CPC clearly suggests that you have to exhaust remedies in the lower court, as per your own reading, why haven't you approached the consumer court? Why are you here?
Your Honor, the relationship between the respondent and the appellant is not such as the seller and the buyer. Therefore, I am not the consumer to the respondent. My claim is completely different. This is a service negligence. And I am not only here to claim compensation as a consumer. I am here to claim a statutory right. Therefore, I have approached the district court and now the appellant court.
Proceed.
Your Honor, the counsel will be dealing with the first and the second issue, speaking for 10 minutes, and the co-counsel will be dealing with the third issue, speaking for 7 minutes, respectively reserving 3 minutes for the rebuttal. If Your Honor, you are well versed with the facts, I would like to, the counsel seeks permission to proceed with this legal.
We are not, because they are just aware of it. Go ahead.
Your Honor, Ms. Ahana purchased a SD Road King 1978 from Mighty Ride, a motor vehicle registered company in the state of Valanadu, which deals with second-hand motor vehicles, which was valued by Little Miss Trouble, who is the market leader in valuating old motor vehicles, valued the motor bike at 8 lakhs.
But Motor Vehicle Act defined as market leader evaluation, something of such pattern is used in the statute.
No, Your Honor, but it is relevant to the fact that she was the market leader, and therefore
Who was the market
They
leader?
themselves claim that a market leader, what is the statutory backing to it? See, as a lawyer, you are submitting in the court of law, but there should be some legal statutory backing to it. They claim themselves as a market leader. Is it being given or accredited by some authority which has statutory power to do so?
No, Your Honor,
Motor Vehicle Act doesn't speak so.
there's
So they are just evaluators.
evaluators. While Ms. Ahana showed interest in buying the vehicle, but was of the opinion that it was not worth 8 lakhs and she was willing to buy it at 5 lakhs. To persuade Ms. Ahana, Mighty Right showed the valuation report done by Little Miss Trouble. This convinced Ahana that the bike was rather unique and expensive, therefore increased her offer by 6 lakhs.
Bike is of antique value. The Indian Road Congress doesn't certify it to be operated or is motorable in road. So value is subjective. Go ahead.
After purchasing the vehicle, she realized that the engine was rusty and did not perform well. And she could not even afford for repair because she had spent all her money in the purchase of the vehicle. She sued Little Miss Trouble at the district court and it was
Yeah,
dismissed.
but if you have approached the High Court, do you agree that as per the Code of Civil Procedure, And the 96, section 96 that you are appealing under, the matter has to be extraordinary in nature.
It does not mention anywhere that the case has to be extraordinary or.
And it has to, is it an absolute right that you are claiming or a statutory?
It is a statutory right, Your Honor.
So what matter comes to the High Court, the absolute right or the statutory right? And then why are you approaching? So that your own admission gives us a ground to dismiss your petition.
But it also says that any aggrieved party to a decision, by the lower court
Exactly.
has at least one right to appeal before the first
So
appellate.
where there is an extraordinary merit or has to be a,
There has to be a cause of action.
which is absolute right.
Absolute.
Here you are claiming, number one, you have failed to convince the court on what is so extraordinary in nature. Second of all, you are saying that you are here seeking for statutory rights.
But there is enough cause of action to appeal before the.
Then keeping that cause of action, go to consumer forum. Go to those forums which is the motor vehicles tribunal.
But the district court has already passed a decree, and the consumer forums cannot go against it and against the decree passed by the district court.
That is the point of these points. Why you have not approached consumer and why you have approached the district court?
First question: why I have not approached the consumer court? I have approached the district court not only to claim my compensation but also my statutory right. There are violations of the statutory rules by the respondent.
What are those? What are those?
Section 247 of the Companies Act 2013,
What it says?
subsection 4, clause 2, where a valuer has
Sorry,
been
counsel,
committed.
which article precisely?
247.
247.
Registered evaluator.
Valuation for registered valuers.
Okay.
Where a valuer.
This is for companies.
Yes.
And this is your motor vehicle. Motor vehicle is governed under different statute. This
But
is for
we are
evaluation.
right.
This is comes when it comes to annexed statute of IBC or something like that.
Yeah,
Or you can take shelter under such statute which doesn't touch your aspects of law.
Your Honor, the question was whether they exist duty of care towards Ms. Ahana by letting us travel.
Who is this Sahara first of all?
Ahana is the buyer.
Ahana is the buyer. Now, what is the professional credentials? She is some bike enthusiast something or something.
she's a throttle queen.
Throttle Queen. So Throttle Queen has bought this vehicle for passion, not to be in action. So you should keep this vehicle as an antique, not to make it as a motor. See, antique cars and bikes should be paraded only at a odd juncture, like a vintage parade. And now she is questioning the engine capacity and motorable aspects. Was she not aware of all these things when purchasing the vehicle? It's an outdated model. And she obviously doesn't comply Bharat 6, carbon footprints and all, pollution norms. Completely it's not motorable. It should be kept inside the glass.
But Your Honor, the valuation of that condition.
Okay, same principle comes into your frame. You should be aware. Your friends also told, you also pursued, and you buy someone's valuation, and you buy it, and again you blame on the valuator again.
Your Honor, can I speak for 2 minutes? I'll do whatever question came. First question was, why did I not approach the consumer court and the district court? As I rightly mentioned, there is no buyer-seller relationship between the respondent and the appellant. The respondent is a valuator, and there has been violation of statutory right, which has been clearly mentioned under section 247 of the Companies Act. They are registered value.
And you can't take it. That's on the company, also that's on a company's law angle. Here we are not on that angle. It's a purely motorable aspect. You can touch aspects of fraud and negligence. That is the way you can play area you can revolve around.
But it is clearly mentioned by the statutes.
That statute will not come to your shelter, no. Imagine if you take Wildlife Protection Act and say my rights are infringed.
No, Your Honor, we are talking about the valuator.
No, tell me, is Ms. Ahana, has she purchased it for any commercial purposes? That's
What is the
exactly
real
what-
purpose of purchasing this vintage vehicle?
Was it some pleasurable ride or some passion of collecting antiques, or was it for some any commercial? Was it commercial purpose? What is the jurisdiction of Companies Act? Okay, we will play in your playground. You tell me what is the jurisdiction, the preamble of your Companies Act.
Read the preamble of the statute, what you are given. Where it applies, where you can use those provisions.
Where a valuation is required to be made in respect of any property, stock, shares, debenture, securities, or goodwill. Or any
Is it a motor vehicle? Anywhere.
any property means.
Where it says any property?
Anything.
Council, that is which pertains to companies. You have to give up this argument.
No,
Otherwise, you don't stand
allow
up.
me to. No, allow me to prove my
Yeah,
point.
yeah.
Okay, can I just have a look at the statute if you don't mind? Meanwhile, you try convincing my brother.
Any property, where is any property land or pattern here? Show me.
Or do you have a Companies Act where
I will read for you, brother. Where valuation is required to be made in respect of any property. Okay, you want to fit into this bracket.
No, sir, please understand the very preamble of it. Like, even if it is a property under what grounds? Is it a property used for commercial purpose? Is it a property which is generating revenue?
That was not mentioned in the proposition. The assumption of facts, if I.
No.
Use your brains now. You don't blame the problem.
Don't blame the.
The assumption of facts, if
No,
I.
it's not. You're not assuming the facts.
You are a counsel standing speaking for the client, on behalf of the client. When you are in court, you can't place it. Assumption is not given. Fictitious stuff cannot be taken by the responsibility casted on you as a counsel. You have basis. Why basis are being owned by counsel? That's the responsibility. Feel the weight of the responsibility, not for the pleasure.
Which page of the law talks about the Companies Act?
In the shoes of a counsel, responsibly argue.
The researcher, can you please help me with which page number of your memo are you talking about Companies Act?
Page number 30, 6 point.
Page number 13. Paragraph number 6.
Your Honor, irrespective of what the intention the bike was purchased for, the valuation had to be made according to the rules.
Exactly. If you're going with the intention of whatever it was purchased for, and you're seeking the premise of Companies Act, every act has a purpose. Yes or no?
Yes.
And
Your client is a company, you are not satisfied on that. Then you will fit into the further course of argument. Your client is an individual or a company.
My client is an individual.
Then how do you fit into this company side?
I'll explain to you.
Then
Subsection 4 says that when a valuer has been convicted under subsection 3, he shall be liable to pay for damages to the company or to any other person for loss arising out of incorrect or misleading statements of particulars made in his report. There were misleading statements in his report, out of which my client was persuaded that the bike was rather unique and expensive.
Then go to NCLT, invoke IBC. Why are you here before High Court, wasting judicial time? And then why you went to Mazhabur to District Court? If you have this in your mind, that has a line of argument. Go to IBC, no. Go to NCLT.
But the High Court has already accepted my opinion.
No, who said it is accepted? It's a course of adjudication. Now and now itself it can be dismissed. Just because clerk accepts in the file, that doesn't mean that you won the case. It doesn't happen that way. The counter, they have mercy and respect to the counsel, they receive it. Ultimately, the court is which will decide the fate of the matter. What is the next question? Excluding your company argument, tell me something new which is interesting.
your Companies Act does not have jurisdiction.
See, don't pursue the court which has no value.
Okay. You proceed.
Other grounds.
I'm trying to explain the court that there are certain rules and
But
regulations.
court was also trying to explain you that court will answer back.
Please allow me 2 minutes. I'll proceed with my analysis. Your Honor, the question here was whether the respondent has any duty of care towards the appellant. Hence, to prove, there are statutes to prove that and also rules given by the central government, which in the compendium, if you can annex the one, integrity and fairness. It is not disputed by the respondent that they are not valued the vehicle. In the course, if the
Where exactly in your compendium is it the Model Code of Conduct for Registered Values?
Yes, sure.
What Indian Road Congress speaks about evaluation, motor vehicle evaluators. What Indian Road Congress speaks about anti-motor vehicles, motor rules. Are you aware of how those
This is the official rule that has been downloaded from the
MCA will not come to your rescue. You are on a different footing. What is the line of the argument you want to put forth before the court of law?
Okay. Your Honor.
Okay, well if we have to buy your MCA argument, tell us what is the definition of companies? How Ms. Ahana or the little, what is this?
Accepting his argument as company code, this code will be demoted to NCA.
No, Your Honor.
So, no. Take the definition, extract the jurisprudence of the Companies Act, tell us how this company who has done the evaluation come under the ambit of Companies Act.
Since Little Miss Trouble is a registered company and section 247 and section 247 chapter
Okay, your point is taken. Go ahead. Chapter is concerned.
there is a particular section just for evaluators.
Okay.
They are defining few rules and regulations. Therefore, as I mentioned in subsection 4 clause 2, they owe to any other person out of which there is loss arise. And also, in the company's registered valuers and valuation rules 2017, fifth point of the integrity and fairness of a valuer. A valuer shall keep public interest foremost while delivering his services. Therefore, they have violated this particular rule. They have not provided accurate information in their valuation.
You are saying they are not provided.
No, Your Honor. In the facts of the case, it is clearly mentioned that after looking into the valuation report done by Little Miss Trouble, Ms. Ahana was convinced that the bike was rather unique
Convinced by
and
whom?
expensive by the valuation report.
By the valuation report
It is up to your wisdom that you you agreed with the valuation of the respondent.
Okay.
So where is the wrong?
Okay, let us just play some time. Let's take a small detour from Dawson now. To whom was Ms. Ahana accountable to?
But Ahana is not accountable.
No, like I mean, to whom was she a consumer? Was she a consumer to Little Miss Trouble or the Mighty Rider?
My dear.
Now, let us come to section 40 of Contracts Act. Now you tell me, how was Ms. Ahana aware of the fact that Little Miss Trouble is the one who was doing the evaluation?
Mighty Right showed the valuation report done by Little Miss Trouble.
Where was your wisdom? Someone shows some report. You should apply your mind. Principle of KV temper is always there.
Okay.
And there your rights are diluted.
So,
First of all, counsel, you are on the wrong court. Second of which, you don't have right remedy before the appropriate court. Convince on the other grounds where you can get remedy. What are the other grounds you want to canvass other than this?
That is the duty of care and we are here to claim.
What is the duty of the case?
As I rightly mentioned in the section 247 and the rules given by the central government, that was the duty of care towards the public.
They have taken duty of care.
They have violated is my point, Your Honor.
That is your assumption. How?
No, Your Honor.
Crystallize.
I just prove that a valuer shall keep public interest foremost by delivering his services. My next point being professional competence due care. Sixth point. Our valuer shall render at all times high standard of service, exercise due diligence, ensure proper care and exercise, independent professional judgment. Another, give me 30 seconds, I will prove my point.
I will give you 2 minutes, not 30 seconds.
In the preparation of a valuation report, the valuer shall not
which page number of memo are you referring to? Your memo, I think you're reading or something.
Yes.
Which page? I have your memo, your copy. Which page?
14.
Yeah. Paragraph?
First paragraph, 9th point. This is given in the valuation rules. In the preparation of a valuation report, the valuer shall not disclaim liability for his or its expertise or deny his duty of care, except to the extent that the assumptions are based on statements of fact provided by the company or its auditors or consultants or information available in the public domain, which was not the case
So
of the
who's
respondent.
obligated for duty of care in this case?
The respondent. Little Miss Trouble was obligated.
How was Little Miss Trouble a qualified respondent in the case as per section 40 of Indian Contract? How do they come under the doctrine of privity of contract?
They do not, there are exceptions.
I will make your job much more easy. I know you are talking. What is your prayer? What is your prayer?
My prayer is to that declare that Little Miss Trouble had duty of care towards Ahana and there was negligence only on part of the valuer.
How you will substantiate? Tell me this. Where was negligence? Where was lack of duty of care? argue on those lines.
Your Honor, as I already mentioned, 2 points. Section
Right
247
here,
of the
definitely
Companies
you're not coming to the point. That is the
Your Honor, Section 247 of the Companies Act and the rules given. There are clear violation of rules by the respondent.
Okay, I'll make your job more easy.
much more easy. Decentralization.
Open Sales of Goods Act and enlighten the court on section 41, 42 and 50.
Thank God you are not taking sentence in the Constitution.
I was expecting someone to pull up a 226.
What is this actually? What is the nomenclature of the petition? RFA? Nomenclature, where is the appeal? Oh my God. How come appeal? How come appeal? First expect me on that. How come appeal? How come appeal? Ah. Yes, counsel, how come appeal?
Section 96 of Civil Procedure.
What appeal? Just appeal.
Yes, Your Honor.
Yes, yes. I made High Court rules of practice. Before filing this petition, have you gone through the High Court rules of practice?
The High Court has jurisdiction to try matters.
Have jurisdiction to try matters, but not in this nomenclature. Not in the size and the shape of the as the you have filed. What appeal it is? Regular first appeal, regular second appeal, civil division appeal. Where it is? Now it is coming from your out of the name. Here where is? Don't show me counsel, where it is? Here it says appeal. What appeal? Is it consumer appeal, national appeal, or you will make it in a cricket appeal? Futile appeal. You make it as futile appeal.
No, Your Honor. Mentioned appeal, case concerning matters related to
Counsel.
duty of care.
Yeah, what is the first
Counsel,
title?
don't beat the bush and don't educate the bench on what is the proceeding. But accept the mistake. What appeal it is has to be stated. Whether it is a petition, whether it is a petition, on what jurisdiction you are seeking relief has to be thought before filing a petition. That exercise has not been done. That wisdom has to be demonstrated. Not here it is. Here it is only I am seeing what it is. Go ahead with your further parts of argument.
Yeah, now convince us on how.
Lack of what all you said in your prayer, no. Convince on those points. Another, you have another speaker to speak.
Yes, on negligence.
Then you relax.
No, is there anything else that you want to?
You want to tell us something else? Other than don't take me back to your Companies Act.
And 247.
In Deadly Buying versus and Company Limited versus Helen.
Facts of the case in 3 sentences.
Again, a new duty was recognized.
Facts of the case in 3 sentences. At least whatever.
Very good. Very good. Are you taking from, again, don't take Hasbury law. Take something which is Indian law. Please present your case. Confined to the scope of arguments.
Your Honor,
Yes.
the third issue is whether Ms. Sahana had contributed to the negligence. It is humbly submitted before the Honorable Court that there was no contributory negligence from Sahana, the appellant, as the theory of the contributory negligence comes into play when there is a person who suffers an injury and contributed to the offense. Here in this case, appellant was not part of the preparation of the evaluation report, not influencing the preparation of the evaluation report. So, the valuer is not prevented from discharging his duty.
Where was the wisdom while accepting the evaluation report? So much of wisdom is now demonstrated before this court.
And if I'm not wrong, the facts of the case says Ahana bargained, no? She was ready, if she was 3 lakhs, she was ready to buy it. So she bargained also. So somewhere down the line, she conceded to the evaluator's report. So now convince the bench on.
So we have the Sale of Goods Act.
Section 41, 42 and 43 of Sale of Goods Act, please, which talks about the buyer's right of examining the goods, acceptance and buyers bound to return the rejected goods. Please, so this very clearly enshrines the rights of the buyer. So did she exhaust any of those 3 sections before buying? In fact, she was ready to buy it for 3 lakhs or 5 lakhs or whatever amount that was favoring her bargain.
Yes.
So where did she exhaust any of those three?
Yes, buyer's right of examining the goods.
Ah.
So she had a reasonable opportunity to examine the goods.
Did she?
Yes.
Before
She
buying?
examined.
She
She examined the goods.
Yes.
Proper queen went on the bike.
Yes.
Everything enjoyed the ride.
Yes.
No.
Yes. She examined the bike, but the engine was rusty.
Ah.
She mentioned that the engine was not performing. She mentioned that the engine was not performing.
That modern itself is known for rustic engine.
No, it was not. She mentioned that the engine was not performing. She mentioned
Did
that
she do
it
that
was
before
not
purchase or
performing.
after purchase?
After the purchase, she told that it was not performing. It was performing when she examined the bike.
So that is the no.
Yes,
When
that's the
this
reason
consumer-
she went ahead
did
and
she
purchased the bike.
pay the purchasing the bike? So after the purchase, is section 40 valid, or is it a right given to her before the purchase?
So it is talking about the distance place. Here, this is relevant to this case, section 40.
To speak about the buyer's rights.
Yeah, the 41, buyer's right.
So did she do it before the purchase or after the purchase? Did she
She
examine?
did all the examinations.
After the purchase or before the purchase?
Before the purchase, prior to the purchase, she did all the examinations. She took a test ride. In a one
Test ride?
Yes. Yes.
Test ride after the purchase. How is it?
Before.
Sir, brother, let's help me understand this. If I want to buy a new car, I go to the showroom. So do I purchase the car and go for a demo test drive? If I'm not wrong, some brands also come to my house. Like if it's like an Audi, Benz, BMW, they come to my house. They give me a test drive. Even before the purchase.
Even nano.
Even nano. Test drive is available at my doorstep. So tell me, how is that test drive possible after the purchase? And if that is possible, which means
Before the purchase, she measured the bike. Before the purchase, she measured.
please
the
help me. Where is it mentioned in the facts of the case?
It was not mentioned. It was based on.
So you are assuming it. So you are submitting wrong evidence to the court.
Reasonable as it. Okay, that is also permitted. We will give that liberty to us.
It is not the case that the same point what I mentioned now. The appellant was not faithful or not prudent enough by purchasing the vehicle. You are prudent enough to correct the valuation report prepared by the valuer. And also,
what was the purpose of purchasing this vintage?
yes. The purpose of buying is not at all an important ingredient in preparation of the valuation report. What are the purpose? The buyer is buying a good. It is unnecessary or irrelevant or insignificant to the value. And
How you substantiate that it is irrelevant?
yes. The
Multiple choice being just proposed will not serve.
yes. I give the fact. Yeah, I give. When we consider the any valuation request form, the criteria is whatever the mentioned is number of kilometers driven in the vehicle, model of the vehicle, year of the manufacture. These are all the things.
When you go by law, the vehicle, the subject vehicle is unfit to be brought to the roads of this country. It is prohibited.
Yes, that is all. She is aware of the antique bike, everything. She doesn't want to use it for the racing purpose. It is an antique.
Then why is she worried about the engine?
If it should be kept in the glass doors, why you are worried about engine?
Yeah, why are you
The
worried?
valuation prepared by the valuer is not proper with respect to the price of the bike.
See, you are just vocally saying the valuator, blaming the valuator. It will not happen that way in the court. You have to substantiate how the valuation was purposed.
Yes.
That purposity has to be demonstrated.
Yes. There are some rules and regulations for the registered values and valuation. As per the
That please, your brother counsel have already taken us to some unwanted territory of law which is not at all applicable to you.
No, which evaluation rules are you talking about?
Again, don't go to companies at least.
No, what is the title of the statute?
registered values and valuation. It's not
Which year was it drafted?
2017 and it is under the professional competence and due care.
Oh,
There is a point which says a valuer shall continuously maintain a professional, knowledge and skill to provide competent customer service based on the up-to-date developments in practice, prevailing the standards, guidelines and the regulations. Here the valuer or the respondent has not at all followed any guidelines or standards.
how you are saying? Out of 15 years you are saying. You
No,
are not
The
following
valuation report says that. being the market leader, the little stubble was not even able to verify the uniform rusty. He ignored that. There was a negligence from the valuer.
You say it is ignored. What is the evidentiary value for your
But
argument?
it's a very basic thing. He
yeah.
ignored the.
My basic question, brother judges, why have you not made mighty right as a party to this?
I don't know.
Mighty right is a very open matter.
So because the appellant completely trusted the valuation report, completely trusted the
You trust
valuer.
whoever you want, but not more than one wants the necessary parties to
No, no.
carry it.
My question is, why have you not made mighty right as a party to the suit?
Where is your cost title?
Ignorance. Okay, you see, researcher. Why have you not made mighty right as a party to this?
The owner is new to the market, and since he has no experience in this, he has approached the valuator. That is the implementation is started.
So he is new to the market, you have approached him out.
For the time will be up.
Yeah, convince the bench why mighty right is not.
First of all, where is the cost title council?
Yeah, why mighty right is not?
If you look at the facts of the case, it is very clear. Both Mighty Rai and Ms. Hana was completely, the whole transaction was completely based on the valuation report. First, Mighty Rai approached the valuator. Second, Ms. Hana was convinced by the valuation report. So both of these parties, that is Mighty Rai and Ms. Hana, was bound by the valuation report.
So you mean to say mighty right is not a necessary party for adjudication?
But here also
So
did
you
my
want necessary parties or necessary parties to the proceedings?
And
no.
In the eye of law, who are all necessary parties or non-joined of necessary parties? That is the
Okay, no. Without touching, without touching the bedrock of the ocean of this code of civil procedure, are you suggesting to the court that, yeah, we'll give you 5 minutes. Mighty Right delegated responsibilities to this little Mr.
they did not delegate responsibilities. If they delegated responsibilities, Little W would have been influenced by the rules given by Mighty Rai. Mighty Rai approached Little W for using their knowledge and experience to give us the valuation.
There is
There was no
principal and agent relationship between mighty right and evaluator.
Simple languages, is there a vicarious liability in this section?
There is no vicarious liability.
Then they should have some strict liability.
There is no vicarious liability.
No strict liability.
So there's no liability.
No liability at all, whatsoever nature.
We are not quoting that, but there is no vicarious liability because
Open thoughts. I'll help you save time coming.
This extended arm of justice is only extended for fishes.
liability of employer for the act of an independent contractor.
So, no. Are you conceding that there's vicarious
There
liability?
is no vicarious liability.
Why?
Because the principal did not give any suggestions or rules regarding how the valuation report has to be done. It was completely at the discretion of the previous trouble that the valuation report was.
Valuation report doesn't happen on discretion. Valuation of the object. So there is no discretion involved.
No, Your Honor,
But
but
if they use their discretion, they will evaluate mindlessly.
it is very professional.
Valuation should always be objective, right? It should not be discretion.
Therefore, there is no.
Good.
And also in the case, I want to mention some case laws which are serious in nature.
Permissible only if you can help us brief the facts of the case in 3 sentences. Which
Like in the case of even was offender.
brief of facts of the case,
Yes.
not the judgment. Facts of the case.
Facts of the case, three parties involved here. One is the owner, and one is an employed painter, and the other one is a defendant, who is a driver company. Okay. Employed painters the stage was supported by the ropes that flung over the sides of the ship. The rope which was used was already scratched. Okay, and they were supplied. Defendant had no direct contact with the ship owner. Still, the painter sued the ship owner for the damages. Basically, the painter was injured when he was
What's the judgment of?
judgment was defendant's fault. It was the ship owner's fault. And with this, I would like to conclude my arguments, and I request permission to present the matter.
Yeah, without looking at the memo. By heart.
In the light of the issues raised and arguments advanced and authority seated, it is most
Without looking at the memo.
humbly submitted.
Without looking at the memo.
It is most humbly submitted that the court may please adjourn and declare that the appeal filed under section 96.
Every time you look down and minus 1 mark over here, without looking at the memo. So what is the first prayer? Minus 1.
Section 96 appeal may be allowed.
Number 2.
And
दुश्मन का है बगल में YouTube.
there is a duty of care from the returning servant to Ahana. And the third one is Ahana had not contributed to the legislation.
And the court may pass any other orders, writ or directions that deals within the interest of justice, equity, good faith.
That we have to be ourselves.
So according to good faith, does the judge do you want to take in Companies Act as a consideration? That is one interim. That's an interim injunction.
Thank
that
God,
we
thank
will-
God you are not for interim. You have to be very careful while wrapping information. You have to take consistent of people who are in the field. What is an appeal? What we are in the court, you have to at least make some extra. You not to be a out of you have to be unique, right? You still can't follow some template which is available in the United States and follow this. Where you are, you have to read the problem properly. Then not only will and which court you are approaching, that we should happen.
Had you written RFA? And because tomorrow when you go to the court, you want nobody will be gracious enough to elaborate it right. You got the MFA, RFA, MISC, WP. And had you written right to first appeal, without even such substantiation and elucidation, you would have answered your first issue. And that's RFA is all about section 96. Yeah? Thank you. So give us a couple of
You had a joyful mood that you will have, now you will have.
welcome to the Ring of Fire.
The Council of the Respondent recognizes the gracious presence of Your Excellency. However,
Your Excellency.
No, we are not president of government. We are just sitting judges.
of Your Honor, however, for the convenience of proceedings, the Council seeks permission to collectively address the bench as Your Honor.
Your Honor. Thank you.
Much obliged. The Council is appearing before the Honorable High Court of Tamil Nadu in the matter of Ms. Sahana versus Little Miss Trouble on behalf of the respondent in response to the appeal filed under Section 96 of the Civil Procedure Code. Your Honor, there are 3 issues involved in the case. The first speaker will be deliberating upon issue number 1 and 2 for a period of 8 minutes, and the co-counsel will be deliberating upon issue number 3 for a period of 8 minutes respectively, reserving 2 minutes for rebuttal. The council now seeks permission to deliver the statement of facts.
We are well aware.
Much obliged. The council now seeks permission to deliberate upon the issues.
And can you please give us a synopsis of what each issue deals with?
Yes, the first issue deals with whether the petition is maintainable by the High Court of Tamil Nadu, and we are deliberating it on the basis of 2 grounds. Substantial justice by the subordinate court has already been done, and no exception.
No. Just what is the merit out of each issue that you are trying to see?
The petition is not maintainable by the High Court of Tamil Nadu. And issue 2 deals with whether there exists a duty of care by Little Miss Trouble to Ms. Sahana, and we are humbly contending that Little Miss Trouble does not owe a duty of care to the appellant.
And issue number 3 is?
Whether there was contributory negligence by Ms. Sahana to mighty right, that is humble inference made by the statement of facts. The council will be deliberating
mean by exceptional circumstance?
No substantial question of law exists and interference is based on pure question of facts.
Yeah, we are deciding the merits based on the substance aspect. We are not getting into the procedure. We are not calling in the representatives or the owners of whichever that is, letter writer and cross-examining him. We are just dealing with the merits of the case. We are just looking into the jurisprudence of the order and we are applying our wisdom to it.
Since this is a regular cost of no exceptional circumstances, there.
No, what is an exceptional circumstance? Like, is there a litmus test to prove that these come under an exceptional circumstance? These don't come under the exceptional circumstance. They have a remedy under 96. If not, I don't know. Maybe they may exhaust constitutional remedies. We have a wider jurisdiction. They have not come to the Supreme Court. They have come to the High Court. So, yeah, so what is an exceptional circumstance? And this is not like some criminal case like how they show in this movie JB, where they suddenly bring in cross-examination in the High Court. This is a civil suit and under 96 we are allowed. So what is the jurisprudence that is there in 96? Are there any limitations given in the section 96?
Yes, Your Honor, we are being held wrongly liable and they are doing the wrong party.
That is subject to discussion.
Circumstance in this case.
You being wrongly liable.
Yeah, because the respondent does not own.
Is your company owned by Queen Elizabeth, Prince Charles, or now the monarch Charles, that you have some immunity? Are you the subordinate of the President of India to say that you enjoy some judicial amnesty?
Even subordinate of president will not enjoy.
To say that you have a judicial amnesty, like what is so extraordinary about you? After all, you are an evaluator. With all due respect to the dignity of labor that you do,
First of all, are you registered evaluator?
yeah, all said and done, you are applicable to the eyes of, you are applicable and you are equal to the eyes of law. And you are here.
You are an evaluator. And their problem is you wrongly evaluate. And now you said you are rightly evaluated.
Under the principle of
What is your background, first of all? How do you substantiate the evaluation?
The respondent cannot be held liable for breach of duty of care as the appellant did not disclose the
No. Do you still want to contain the maintainability or do you admit to our fact that it is maintainable?
We still want to
Contain it.
answering the Honor's question. The appellant did not disclose the purpose of purchase as she should have according to the law of laws, as it is clearly stated in the facts that Mighty Red dealt with unusual and antique bikes. The respondent accurately valued the bike and the consumer must have been informed of the same and should have taken necessary precautions when she was buying the bike.
Okay. We will. Sorry.
See, you say buyer should be precautionary. Isn't it other way as well? As an evaluator, aren't you use your technical expertise in a proper and judicial manner and render your service to the larger public? And isn't it duty casted by law as a registered evaluator to evaluate properly? In spite of it's an antique value. Isn't it exorbitant to quote that amount and paint it in such a way that it is equated to that amount? Isn't it wrong and misleading?
Yes, Your Honor. Caveat emptor is an exception to fraudulent cases, but it is not a fraudulent case, so it does not apply in this case.
You say that, but how you substantiate your evaluation was proper? What was the backing?
Because we were evaluating an antique bike and it was not for the purpose of use.
Motorable use.
Yeah.
What is your next course of argument?
That the petition is maintainable under the Act.
Thank you for coming back. Now, tell me in 3 points, not more than that, as to how it does not qualify under substance.
Do you know what is substantial or what is
Procedural law. So, are we permitted to look into procedural law or substantive law? No. That means the court in court okay. 3 points, not more than that. Okay, discount. Yugadi.
You should argue, you should not read.
The applicant has not exhausted all legal remedies as they should have approached the Consumer Dispute Redressal Forum as per section 34 clause 1 of the Consumer Protection Act 2019, but they approached the district court instead.
They say no, they are not at all a consumer. Their prayer is very clear. They say they are not at all a consumer. They are not a consumer. There is no consumer and purchaser and buyer relationship at all.
Then they shouldn't be suing us for breach of duty of care.
They are suing you because you gave some doctored valuation
But Your
report.
Honor, there is no contractual relationship between we are just.
Just because there is no contractual relationship, doesn't it get away from the eyes of the law? Wrongdoer has to be punished.
Yes, Your
Yeah,
Honor.
And that is where our jurisdiction comes into play.
Yeah.
Just because there is no contractual obligation doesn't mean that everyone is scot free.
Quoting Justice H.R. Khanna, the arms of justice is long. So yeah. Okay. Sankranti offer. 2 points how this is not a substantive. Tomorrow's Ethnic Day offer. 1 point which says that this is not a substantive.
Moot offer half and half is great.
And how is it not entertained under section 96?
See, what are the exceptions given under 96?
The average court observed in Vijay Prakash B. Mehta versus Collector of Customs that the right to appeal is neither an absolute right nor an ingredient in natural justice. It is to be noted that the district court was
But it's still a right. It's still a right.
But the district court was not erroneous in its judgment. They evaluated
Our district judge was not erroneous, and it was prudent and reasonable order, or a speaking order on itself. Convince on those.
Since the district court has carefully evaluated both the facts and the laws and they have come to the conclusion that it was did not do a duty of care to the applicant, to the petitioner, and the negligence lies solely on the applicant side because they should have taken due care before buying the bike because the contractual relationship was between Ms. Ahana and Mighty and not between Ms. Cousin.
So you are not a necessary party to the proceeding. That is your line of argument.
There existed privity of contact between the applicant and Mighty right, and after making the counter offer, the first offer automatically gets rejected, and the Indian Contract Act grants rights to benefit from a holder party liable only to the persons who are parties to the contract, and no other third party can enjoy the rights or suffer liabilities under it.
So now we are moving into issue 2. So you issue 1, you admit that we have jurisdiction. Okay. Tell me the essentials of negligence. Explain the essentials of negligence. Simple and straight. Let me ask. Was it something that Miss Ahana could see? Was it a foreseeable?
Yes, sir.
How?
It was foreseeable because she had to stay the purpose of her purchase and
Because she has a nice. You see the engine and it is proper.
Mighty was dealing with antique bikes, so she was supposed to be informed of the same, and
She was just a bike enthusiast, and she is not expert in automobile engineering. There's a difference between rider and a technician. She is not a technician. She is just a rider. She knows the skill of making the velocity of the bike, use the velocity of the bike and win a race. And she doesn't possess the technology and the know how the velocity is generated.
Your Honor, she had a good knowledge about bike according to fact, and any prudent person would check the basic elements of a vehicle before buying it. And the basic element of a vehicle is an engine. So she had to check the engine before buying the bike. And she negotiated. First of all, we had Litmus Trouble quoted the bike at 8 lakhs, but she bought the bike for 6 lakhs. So our offer was automatically rejected.
But the worth of the work that you have done is 3 lakhs. So somewhere you have still inflated and conned them of 3 lakhs.
But there's no substantial evidence to prove that this was not done.
What
by-
substantial evidence do you need? It's in the facts of the case that you have spent 6 lakhs.
That is prudent man will make up.
The facts stated that Ms. Ahana found that the bike in that condition is only worth 3 lakhs. She's not backed by any law to state this. Just like you're saying, we are not a registered company.
No, we never said.
Like,
We just asked what is your
What is your
registration?
the learned counsel also stated. We can also state that Ms. Ahana.
Don't say something out of thin air. It's something out of the substantial emerging from the law, the statute, and the facts.
It also says that she did not have sufficient money to get a second evaluation done.
That is our problem. Just because the poor man should not suffer, just because she doesn't have financial caliber or capability to get it evaluated elsewhere, that doesn't get a right to quote inflated price, does it so? Is it fair on your part, first of all? Being registered evaluator is a duty casted by law, that to be very fair to the general public. When that itself is not being satisfied by a registered evaluator, what the court and the system and the country has to expect from such evaluators? Tomorrow they will put some cycle and affiliate it to 1 crore and some idiots buys it.
The council is more strongly contending that they have not overpriced the bike and there is no negligent misrepresentation from our side. The negligence is solely on the.
Then how did 8 lakhs become, how did 3 lakhs become 8 lakhs?
3 lakhs is also a speculation unbacked by facts.
Okay.
Because it was Ms. Sahana who said that the bike was in that condition was worth 3 lakhs and no authoritative party said that the bike in that condition was 3 lakhs. So we cannot assume that the bike was for 3 lakhs. It could be for 8 lakhs because it is an antique bike.
Convince the court on how have you passed the test of section 18 of Indian Contracts Act? What does section 18 of Indian Contracts Act say? Researcher. So researcher, I'm asking you, it's okay. You answer.
You need to power to resume. No, okay. You will make a brief minutes. Justice cannot be dispensed in dark.
What's the role of justice?
The council is vigilant for not adhering to the Indian Contract Act. Instead, they refer to Bill of Moot Act and the Code of Civil Procedure.
Before you move into case of Moot, as we have given you a small reasons, right? The judge will extend its long arms of aid and we will make you read section 18, will give you adequate time.
We express gratitude.
Read and tell me how have you passed the test of section 18 of Indian Contract.
Okay. That's why we are giving a short break. Come on.
Section 18 clause 2 says that any breach of duty which without an intent to deceive, there is no substantial evidence to prove the fraudulent or deceptive intention by Ms. Trouble to Ms. Sahana.
Okay. Go ahead with your next argument.
So where do you contend that there has been a reasonable foreseeability?
Reasonable foreseeability before buying the bike. Like when they showed her the bike and she bought the bike, according to
Yeah, after purchase is when you have given her a free ride and all that.
yes, sir.
So where is the reasonable foreseeability?
After the test drive that she has undertaken,
Test
she
drive?
must have reasonable.
So will you contend to their argument that she took a test drive? After purchase. Test drive after purchase? Oh, I love this.
Your Honor, mighty right should be held liable for breach of duty of care and not negligence of
Next course of line of argument.
It seems like the Council of Cabinet is defending the respondent. It is contended in the Honorable High Court that the respondent is not vicariously liable for the actions of the dealer, mighty right. Vicarious liability arises when the relationship between the parties.
No, they didn't even contend to vicarious liability. I don't know why are you even raising that as a fact of the case. We very clearly asked them, are you hinting at vicarious liability? They said, no.
They said voluntary not fit injury. Aram se. Go on. You mean to say you are not liable? How you are not liable? How the order of the trial court is prudent enough to quash this present appeal?
Because there was a privity of contract to say.
So was Ms. Throttle Queen aware of the fact that you were evaluating the matter in the first place?
That is not stated in the contract.
So section 37 of Indian Contract Act. So do you think that you have breached section 37 of Indian Contract Act?
Don't attribute all your ignorance to the problem. The liberty, creative liberty is given to you.
Section 27 of the Indian Contract Act states that the parties to a contract is either perform or offer to perform their respective bought the bike for 8 lakhs, but they haven't bought the bike for 8 lakhs, they bought the bike for 6 lakhs, so they should sue multi-ride.
And can you please elaborate the quote on your relationship with Mighty Red? Is it a principal agent or is it
It is an employer and independent contractor relationship. So, vicarious liability arises when the relationship between the parties is that of an employer and independent contractor. It is contended by the respondent that this relationship, that of an employer and independent contractor, was broken the moment the counter offer was made by the applicant, and there no longer exists a duty of care between a dealer and the applicant.
Is there anything else that you want to content? Or?
Yes, Your Honor. Speaker, the co-counsel is dealing with third issue, possibility and duty.
Can I please have my copy of the contract?
The council seeks permission to begin the proceedings with third issue. Issue number 3, whether Ms. Hana had contributed to the negligence, is substantiated on 3 sub-issues. Number 1, the issue could have been avoided to the applicant's duty of ordinary care. Number 2, the applicant had the opportunity to avoid the incident through the rule of last opportunity. And number 3, the applicant is responsible for his own wrongdoing. This is something contended with the Honorable High Court.
Can I know which page number of this?
Paragraph 24.
We want to see.
In having contended before the Honorable High Court that there was contributory negligence on the part of the applicant, as the negligence was caused by the dealer Mighty Right, and as the incident between the parties has caused, could have been entirely avoided if the applicant had exercised due care. It falls within the ambit of ordinary care and does not require the use of any special skill. Contributory negligence is applied when the injured person does not take reasonable care in his own interest and contributes to his own lack of care for himself. In the present case, the applicant did not take reasonable care to ensure that the bike was in proper condition, as proven by the statement of facts previously that the applicant had a good knowledge about bikes.
Since she had knowledge about riding bikes, she is not an automobile expert. She is an automobile enthusiast. There is a difference between automobile enthusiast and an automobile expert. And just because she is an automobile enthusiast doesn't mean that she is an automobile expert. So is not casted on her. It is casted on the evaluator to evaluate properly, because larger public interest is responsible for it. So in that being the case, you should act and conduct in a fair manner. That is what being expected being a registered evaluator. So there is a deviation in your responsibility.
Except if we buy your argument, then there would have been no need for Ahana to approach you at all, or even through the agent. She would have just been like, you give me the bike, I'm good at it.
Your Honor, the applicant would have foreseen the.
When you cannot foresee, how a layman can foresee?
Engine
Engine is a packed engine. It is not transparent. That expertise you alone got. Instead of using your wisdom, you want to rely on someone else's wisdom who is layman. Is that permissible?
The applicant could have taken a test drive could have taken.
You can't presume, and you can't impose something on a general public. Then why are you an evaluator? De-empanel yourself and go home.
You are an experienced evaluator. You are a
Why
market leader.
people foster interest on you? That is not expected. No. If you want to shy away from your responsibility, don't be in that position. You expect them to take a ride, and then what is the use of your certification? Why they want to get certificate from you? Because people repose trust on you. You can't live up to that trust. But then de-empanel yourself for being registered evaluator.
So it's the ordinary care that she should have taken.
You have not taken ordinary care. That is what this court feels. Inflated price. What is the cost for inflated price? You are selling the vehicle which is not motorable, not environmental friendly, and contributing to the carbon footprint to 8 lakhs. And the layman get bike for 1 lakh. How can you inflate to that extent? Which doesn't even comply the safeties of as stipulated in the Indian Road Office.
Your Honor, might be right, I think according to
can't, as a evaluator, you can't go on speculation or whatever. You can't take shelter under there. As an independent evaluator, you have to bank upon your knowledge, experience to evaluate a bike. Whether evaluation pays so much or not. And for any reasonable person, for a common man, an outdated two-wheeler which doesn't comply with the emission norms of the present day of this country is inflated to 8 lakhs. And this being a two-wheeler, I don't think it is being gold-plated, a silencer or something like that.
Yeah, at the mighty rate charge, the amount would have understood the antique value, the rarity
But
of
add-on and so on, all the market will play. As in, what is your duty as an independent evaluator?
Sir, Your Honor, when Little Struggle quoted the bike for 20 lakhs, the contract was already voided because Mighty Ride and Amana had convinced and come down to the purchase to 5 lakhs.
That is immaterial for you.
Yeah, our contention is, on what grounds did you charge 8 lakhs when the vehicle or the usage of the vehicle is all absolutely deformed? If you are telling me that it's an old vehicle, etc., antique value, that is the job of the mighty rider. Your job is to evaluate the nuances of the vehicle, see if it is applicable, so look into the durability, the life, etc.
It's a very nomenclature of your company is in trouble. You get people into trouble. No. You heard enough. Come on, answer the question. Or go ahead with your arguments. What is the other line of argument you want to present?
The rule of last opportunity, the applicant should have
Appellants should have what?
you had the last opportunity of avoiding the incident would be solely responsible, notwithstanding the use of last opportunity. The applicant might be right to have tested the bike before purchasing it and should not make use of the opportunity provided to her.
That is different. That is an economic different thing. That's you are getting to as of that is different. Just because consumer is not aware, that doesn't give you a free hand to mislead the consumer. That is not that. That old principle is now in Supreme Court evaluating it. Give it temperate to an extent is okay. On the face of it, if it is available, if imagine if it is a foodstuff, expiring shelf life, you can go on the face of it. But this is purely a technical aspect. You can't make fault out of on the face of it. This error apparent not on the face of the record. It's something where the expertise has to be called in and put into action. Then alone a report will be generated with respect to the viability of the product. And that is why you are called upon. And that is what the problem is all about. You have not done the issue properly and inflated the price.
In simple sentence, it was not foreseeable to her. Hence, they gave you the far-sighted task of evaluating it. So you have reached the duty here.
And that is why they are entitled for damages.
This has been a pure case of consumer violation.
Unlawful trade practice. Unlawfully enriching at the hands of the innocent and the poor.
LNT doesn't come in, Little Struggle doesn't come into the contract. The contract is between
Okay.
Mighty Ride and
We are not even touching upon contract now. Both me and my brother just change the premise. We are into unlawful trade practice and consumer protection. Here, you are cheating. You are selling your evaluation at inflated prices, which is an unethical practice. Both from the norms of competition law. I don't want to touch into the premise for obvious reasons. Second, consumer protection.
Ultimately, national justice. They are misleading the entire society.
So, I'll not enter into the premise of competition law. So, it's okay. So, under the Consumer Protection Act, you have clearly violated the law.
the right to seek redressal against unfair trade practices as defined under the subsection of 47 clause A.
Of which act?
Consumer Protection Act.
47?
Subsection 47 clause A.
To
Under
entertain
section A.
which part of 47?
47.
I have section 47, clause 1 or clause 2 or which one?
Clause 5. Subclause A.
Clause 5? I'm sorry, consumer protection does not have 47 clause 5. It stops at 4.
Under section A.
Now make up your mind, 47 or 8?
Section 8.
For which act?
Consumer Protection Act.
Which year? It is recently amended at 19.
Consumer Section 8, okay.
One thing we should acknowledge is, okay, your nomenclature is wrong.
Which one under 8?
Subsection 5.
8 does not have subsection 4.
The right to seek redressal against
The 8 talks about District Consumer Protection Council.
8.
Which statute are you quoting?
under Section 8 of the Consumer Protection Act.
Please give me your consumer protection.
Take a recent where I did agree with 19 and Baradilla.
Nimsa Allied details. This talks about District Consumer Protection Council, which is remotely, scarcely connected to this case. It's bereft of everything that you're arguing.
9 clause?
9 or 8 clause 5.
8 clause 5 will be able.
8 clause 4 get that.
That is not a district consumer protection council.
So you're violating the Consumer Protection Act. What researcher? Answer. What? Why are you pointing fingers at your speaker? What? Tell me. You should have touched premise upon this law, no?
Apologies, Your Honor. It is Section 2, Clause 47.
That's a definition clause.
Okay, tell me what about section 2 plus 47? Section 2 plus 47 what? A, B, C, D, E, F, G. H, I, J. It stops at J.
Unfair trade practice. Unfair trade practice. Unfair trade practice.
47 clause which one? Is it just 47? Plain 47?
It's Section 2 of
Suppose.
We are there on 47. Our eyes are there.
Yeah, unfair trade practice.
policy represents that the goods are of particular standard quality.
I'm sorry, ma'am.
Clause A, 47, subclause A.
Yes, yes.
Section 2, clause 47, subclause A. Clause 3 represents the goods. Tell me, how it is applicable?
Particular standard quantity, composition, style, or model. Subclause B, policy represents the service of particular standard quantity or grade.
How this is helpful?
No substantial evidence.
In fact, this is against you.
This is against you.
In fact, you come to see rebuilt, seconded, renovated, reconditioned, or old goods as new goods. For 8 lakhs, ma'am, practical example, for 8 lakhs, you are getting a new bike. You go to a TVS showroom, which is the
new car.
new car, and you have evaluated an old bike for that cost. Second-hand Innova is available for 9 lakhs. Hayabusa is 7.5, the old model. Bullet was 4 lakhs. Your job is to evaluate second-hand vehicle. Even if I give the benefit of doubt and say that, okay, chalo, you have evaluated for your expertise, for your knowledge, and for the kind of people who are in the business have done the evaluation. 8 lakhs, ma'am. Second-hand Audi is available at 10 lakhs, which is a sedan class, A4. If anybody is a motor vehicle enthusiast, will tell me. The 2010 model. An A4 class is of, you get it for 10 lakhs. SD bike antique value, 8 lakhs.
Conclude.
Before sir, I want.
What should not become another Sunday by Cardoza?
Take it. Read 86 of Consumer Protection Act. Convince the court on how you have not violated any of it. Can you please fill in their names itself because one team has filled in their names. Team for a minute. Council. Proceed.
Your Honor, there is no proof that this comes under a fraudulent case and that is
How? 8 lakhs. I'm just telling you how it's a fraudulent case. We are literally charging 3 times the value of a brand new bike in the market.
Not justification.
I know your job is just evaluation.
Your Honor, it's an antique bike and hence it is
Antique bike, exactly. If Mighty Rider would have charged so much, we would have still got the argument. Say it's an antique bike, rare in the market, one of its kind, driven by some Kamal Hassan signature on it. We would have taken it.
Driven by Appu.
Or it is driven by Puneet Rajkumar. We would have taken that argument. Your job is evaluation. But evaluate, did your charge?
These materials things should not affect your evaluation. That's not your job. Yours is a purely technical job. What is the other line of arguments?
Make sure that it's not wrong. Just see that it's a great evaluating.
Conclude.
Don't
Don't be speechless. The court will become motionless.
So you have no argument to convince us on how it's not 86?
They are living at liberty and wisdom of the court to decide. And it will be decided.
Your Honor, Mighty Bike is new to the market. New to the market.
But you are not.
You are a old player. Lack of application. Conclude.
The man seeks permission to deliver prayer.
So you have no argument? You need to convince us of that? You give up? Yeah. Without looking at your memo. India.
What is your career answer?
Therefore, the right of fact statement, arguments advanced or authorities cited, is most humbly prayed before the Honorable Advocate of Tamil Nadu that it may be graciously pleased to adjust and declare, number 1, the appeal is not maintainable before the Honorable Advocate of Tamil Nadu. Number 2, the appeal does not exist. That does not exist. The duty of care from the respondent to the applicant. Number 3, there is contributing negligence on the part of applicant to the respondent. And or cause any order that the court may deem fit in light of justice, equity, and good conscience. And for this kindness, the applicant has duty bound with the rest of complete.
This court is also duty law. Thank you, yes.
Just give us a couple of minutes. We'll adjudicate and we are allowed any feedback, ma'am?
Yes.
Just give us a couple of minutes. We'll conclude.
Guys, the problem is given. Yeah, given the benefit that you are freshers, so it's a golden opportunity. So much of time, energy, and skills are spent. So much of human effort of faculties are spent on you guys to give the exposure of how the real code functions. When that is an opportunity being given to you, make good use of it. Go for a detailed preparation. Read the problem carefully. And if you have concerns with the problem, go to the faculty and get a clarity on it. And get an assistance of the faculty, which are the areas we should look into. And while preparing the draft also, be very cautious enough what they are drafting and the way we present. Because tomorrow you step into the court of law, court will definitely not encourage the casual attitude. Now you have the benefit of being freshers. So in days to come, you will be participating in national level moot court competition or inter-college or inter-university moot court competitions. Have a glimpse of how they present. Participate. Now it is available in YouTube and all. You can see how they present. And go in detail. See, as you are in the very infancy of legal profession, you should make more efforts. Then alone you can champion as a lawyer. it's a first time, it's a very good presentation from all of you guys, very good effort from your own first years, I believe. It's very good, very good. You should thank the faculty for giving such an opportunity at the early stage of your career. See, most students, their faculty are always busy in their academic career all the time. They have carved out time in their career and attributed to for your growth. This work will definitely nowhere will reflect in their career graph. This is purely for your growth and overall development. When that has been the effort made by the faculty. So you should also equally contribute from your end by making effort, by learning, going into the research in detail. What you have, whenever you are going to present your code of law, you should go to the rules. What the rules means. Where we are standing, what is the appeal, whether it is a statutory right, what is a constitutional right. You should go in detail. Take assistance of the faculty, then prepare a memo. First prepare a draft memo, show it to the faculty, correct it. Then if you want to review it, revise it, bring it to the proper format, then canvas it, costs, what it is that. Good presentation, only thing is need some more effort as you are just first year, just passed out from PUC. And this is a golden opportunity for you guys. Don't give up at this stage. It's a beginning. Take it as a motivation, participate in more Moot court competition happens in days to come, and be a rigorous reader. Really update yourself by reading. Spend time, half an hour, 1 hour reading Hindu. Not Times of India or Mirror or something, toilet papers. Read Hindu. Read Deccan Herald, read Indian Express, competitive success story, read Digest, read case laws of Supreme Court. You can get it online. Now the judge of the Supreme Court is very digitalized. Anything and everything is available in internet. So that being the case, make use of it, and we have a wonderful faculty available in the college. And we have wonderful infrastructure there. See, I came from the very good college. And the level of infrastructure I had at my point of time in 2005, I took it 23, and we have such a gigantic shift in infrastructure wise. Please make use of this wonderful atmosphere and as well as infrastructure. Tremendous library you have. So make use of it. I can proudly say, as I'm also associated with analysts, I can proudly say on record that B.M.S College of Law is no way less than analyst infrastructure wise. You don't see, I feel that a little bit of benches out there are compared less when compared to common college. And so benches are also part of it, but I know too much. So, you make an effort, make use of this infrastructure, make use of very good faculty available, principal, then be a better person. Okay? Thank you.
Thank you, sir.
Mr. Raman is a very scholarly person. He has a wide expertise in conducting competitions and all across Karnataka as well as state of Telangana. So take guidance from him as well. He will be available. And he is the most generous person. Or have illa hello sir. Until unless or illa no presidi that. Hello.
So what's up, people? How's it going? Huh? How did you guys find the round? People are God. What's popular, what's the. How did you find the rounds?
Nice.
Good.
Good, sir.
Good for the sake of it, or do you actually mean
No,
it?
don't see it as an entertainment phenomena. See it as an angle of the learning curve.
Huh?
See,
You could have allowed us to speak more.
I'm not to speak. We have to interrupt because that is where the real advocacy comes into. We are here to not to listen to you. We are here to interrupt and bring out the real advocacy. We be the mute spectators. Then what's the purpose of moving? I understand your concern, but that the intention of judges are different. Because we have to bring out something stuffing, If you keep on reading and if we have left him to keep on reading what he wants to say, where is the scene? ಯಾವುದೇ ಒಂದು ವಿಗ್ರಹ ಕಲ್ಲು ಶಿಲೆ ವಿಗ್ರಹ ಆಗಬೇಕು ಅಂದ್ರೆ ಅದಕ್ಕೆ ಏಟ್ ಬೀಳಬೇಕು. ಆ ಏಟ್ ಬೀಳಿಲ್ಲ ಅಂತಂದ್ರೆ ಅದು ವಿಗ್ರಹ ಆಗುತ್ತೆ. 2 ಕಲ್ಲಿತ್ತು ಬೆಟ್ಟು. ಒಂದು ತುಂಬಾ ಕೋಟ್ಯಾಂತರ ವರ್ಷದಿಂದ ಫ್ರಮ್ ಏಜಸ್ ದೇ ಆರ್ ಫ್ರೆಂಡ್ಸ್. ಒಂದು ಒಬ್ಬ ಶಿಲ್ಪಿ ಬಂದಂತೆ ಎರಡನ್ನು ಟೆಸ್ಟ್ ಮಾಡಿದ್ವಿ. ಓ ದೇ ಆರ್ ಫ್ರಮ್ ಬೀಚಸ್, ಕಾರ್ಬನ್ ಡೇಟಿಂಗ್ ಇಸ್ ವೆರಿ ಗುಡ್, ದಿಸ್ ಇಸ್ ಗುಡ್ ಫಾರ್ ಮೇಕಿಂಗ್ ವೆರಿ ಗುಡ್ ಐಡಲ್, ಶಿಲ್ಪಬಲ್ ಐಡಲ್. ಒಂದು ಕಲ್ಲು ಇಟ್ಕೊಂಡಂತೆ ಅದ್ರ ಮೇಲೆ ಕೆತ್ತನೆ ಮಾಡಕ್ಕೆ ಶುರು ಮಾಡಿದ್ವಿ. ಆ ಕಲ್ಲು ಅಳಕ್ಕೆ ಶುರು ಮಾಡ್ಬಿಟ್ಟು ಅದು ರಕ್ತ ಸೋಸಕ್ಕೆ ಶುರು ಮಾಡ್ಬಿಟ್ಟು ಕಲ್ಲು. ಪಾಪ ಅವನು ಶಿಲ್ಪಿ ಬೇಡ ಬಿಸಾಕ್ಬಿಟ್ಟು, ಬೇಡ ಈ ಕಲ್ಲು ಪಾಪ ತುಂಬಾ ನೋವು ತಡ್ಕೊಳಕ್ಕೆ ಆಗ್ತಲ್ಲ ಬಿಟ್ಟು ಇನ್ನೊಂದು ಕಲ್ಲು ತಗೊಂಡಿದ್ದ ಅದರ ಬ್ರದರ್ ಕಲ್ಲು. ಅದು ಒಡ್ಸ್ಕೊಂಡು ಚಚ್ಕೊಂಡು ಚೆಕ್ಕೆ ಹಾಗೆಲ್ಲ ಇನ್ನೊಂದು ಶಿಲೆ ಆಗಿದ್ದು ಶಿಲೆ ಆಯ್ತು. ಅದನ್ನು ತಗೊಂಡೋಗಿ ಗರ್ಭಗುಡಿಲಿಟ್ಟು ನಿತ್ಯ ಪೂಜೆ ಮಾಡಿ ಪ್ರಾರ್ಥನೆ ಸಲ್ಲಿಸ್ತೇವೆ. ಇನ್ನೊಂದು ಅರ್ಧಕ್ಕೆ ಹೊಡೆದು ಓಡಾಯ್ತಲ್ಲ, ಅದನ್ನ ಅದೇ ದೇವಸ್ಥಾನದಲ್ಲಿ ಚಪ್ಪಡಿ ಹಾಕಿ ಹಾಕ್ತಾರೆ. ಒಳಗಡೆ ಕಲ್ಗೆ ಅಭಿಷೇಕ ನಡೆಯುತ್ತೆ, ಜನ ಪ್ರಣಾಮ ಮಾಡ್ತಾರೆ. ಈಚೆ ಕಡೆ ಕಲ್ಗೆ ತೀರ್ಥ ತಗೊಂಡು ಜನ ಒರೆಸ್ತಾರೆ. ನಾವು ಯಾವ ಕಲ್ಲಾಗಬೇಕು ಅಂತ ನೀವು ನಿಶ್ಚಯ ಮಾಡ್ತೀವಿ.
So what did you learn sitting in the last bench? Yeah? The last bench boys. How was the rounds?
It was good, sir. It was
Had
great.
fun?
Yeah.
What did you guys learn out of the? What was the outcome?
Honestly, like we wanted to take part in this Moot and we couldn't, and I think we've got to know how we should prepare for the coming Moot.
Coming to the participants. What about you guys? How was the experience?
We never expected to read thoughts in the first year, sir. And we didn't know that we had such potential to go through all this. And we always demotivated ourselves, and now I guess this thing will keep us going on.
ಸರ್ ಫಸ್ಟ್ ಮಾಡಿದಾಗ ಇದು ನಾನಾ ಮಾಡಿದ್ದು ಅಂತ ಅನ್ಸ್ಬಿಡ್ತು ಸರ್ ಮೆಮೊ ನೋಡಿದ್ರೆ.
Coming to the participants. How was the final? How was it different from other rounds?
Very intense. In the other round, they did ask us so many questions and then take on every stage of us. But that was very nice.
ಪ್ರೀವಿಯಸ್ ರಲ್ಲಿ ನಿಮ್ಮ ಮೇಲೆ ಅವ್ರಿಗೆ ಗೌರವ ಪ್ರೀತಿ ಎಲ್ಲ ಇತ್ತು, ಅವರೆಲ್ಲ ನಿಮ್ಮ ರೆಗ್ಯುಲರ್ ಫ್ಯಾಕಲ್ಟಿ. ನಮ್ಮವೆಲ್ಲ ಇಲ್ಲ, ವಿ ಆರ್ ಸ್ಟೋನ್ ಆರ್ಟೆಡ್ ಪೀಪಲ್.
So it was very interesting. Now we have some idea about how she will do the research.
See, for a lawyer or a law student, I personally believe it is a dynamics. It's not that we are in first year or second year or final year. I see a lot of final years not even to be able to answer basic fundamentals of law despite spending 5 years in the course. And at the same time, in my experience, little experience of teaching in 1 year, I have seen youngsters, first year, second years, extraordinarily speaking about concepts of law. So, age, class, semester is just a fictitious thing in your mind. Wave out all those stuff. You are a law student, you are a law student. No one forbids you from studying constitution. Is when you go to step into the library, even librarians say, no, you are a first semester, you don't touch constitution. No. It's an open arena. The thing is that you should have a willingness to learn and openness to acceptance of knowledge.
So beginning from the drafting of the memorial, I think our team found out the most number of case laws, so 20 Indian case laws and 7 international case laws. So we learned a lot from each case, and also I agree with Sima that the judges should keep interfering and asking us questions.
How did you find them out? You're not asking our feedback.
It was good, sir. Exactly. So that creative element in me came out when you were interfering and asking. So research and creativity.
If winning or losing, guys, it's a process of education. Where you have been to lose, that is a different issue. The process of learning, I felt it is completely done with the tremendous amount of your faculty's pressed into action. They have their other responsibilities also. We spent so much of time in bringing this into operation. So, thanks to the faculty and the entire team who brought this into action. Thank you.
To conclude, well, to begin with, now this is where I exercise my right to speak. In principle, what the courts fundamentally follow is the adversarial system, wherein, as he said, you will be given enough opportunities to argue and you substantiate your facts and you are given an opportunity to put your case. But in the Moot court, we follow something called as the inquisitorial system because we want to extract the merit. Because understand, if you are appearing either in the High Court or the Supreme Court, in District Court at least it's bargaining with the dates. The game exists in the first 30 seconds. Remind you, the game is in the first 30 seconds. If you are able to convince the court in the first 30 seconds, the rest of your prayer comes into play. The rest of your summary of facts come into play and arguments advanced come into play. The game is in the first 30 seconds. Second, now immediately when I asked a question, that, like, what would you want to address the bench as? Why your lordship? Why not? And sir also was throwing light on Indian jurisprudence. The very minute that you called us your honor, your purpose is defeated over there. Your honor comes only in the local courts, in the courts which are lower in hierarchy. From Supreme Court and above, it's either sir, where some judges want to drift away from the colonial practice, and your lordship as a respected practice. Some of them want to carry this badge of honor even after retirement. So be very, very careful as to in which court, because if you go say, my lords, when you're doing trial advocacies in the future, your lordship don't apply to district courts, courts of small causes. Again, when you are appearing before an international tribunal or the ICJ, it's the presidency. If you are appearing before the chair of the, let us say, United Nations Security Council or any of the good offices of the UN, excellency comes into play. Again, there it varies. So first, understand the designation. Understand the protocol. Second, always, and why do we ask you such questions? If you notice our questions, we were not even dealing, of course, later stages we were entitled to. But why were we asking you all to emphasize on the facts of the case? When you touched premise on competition law, you were only hitting at a particular section. Why we were trying to distract you from that particular section? Because in due course of time, in practice, always remember, when you're wearing the gown of an advocate and when you're donning the role of an advocate, always facts is the king and not the law. You use law and jurisprudence to substantiate the facts of the case and never the other way around. So if you think that the Supreme Court judgments that you're going to cite or the statutes that you're going to cite, sections of law will impress the bench, absolutely not. Because jurisprudence by definition is application of common sense to law. In later days when you're studying jurisprudence, it is the cornerstone of the entire legal system without a definition. At least a statutory definition. So, always logic is the king. You always try to prove in the court of law based on the question of fact. Support it with question of law. And never the vice versa. So first show that you are the king of the facts of the case. And then get into the nuances of law. Foundation is the fact. So that is one thing. Thirdly, while arguing, always use the protocol language. If I may present, if I may, I plead this honorable court. And whenever the court questions, you never say that this section is wrong, sir. Always use the language that if the counsel would like to correct himself, the counsel asks himself a question, that the bench has given a question, but whether this question is applicable. You don't say, you never try to correct the bench in itself. The counsel asks himself a question. Use this kind of a language where it's always your case. Alright? And thirdly is the modulation. I saw this team, you guys were confused, you guys were exchanging. See, the very body language of purpose is defeated. Use a chip or always try to communicate. Never show that you are lost. One fundamental rule as an advocate. Two fundamental rules, that is, you ಒಳ್ಳೆ ಜಗಳಗಂಟಿಗಳಾಗಿದ್ದಾರೆ ಒಳ್ಳೆ ಅಡ್ವೊಕೇಟ್ ಆಗಲ್ಲ. ಮೊದಲನೇ ನಿಯಮ. ಎರಡನೇ ನಿಯಮ, as an advocate, you are never wrong. As an advocate. So maintain that attitude, that stubbornness should come within. Never ever concede. Thick skin. So whatever you say is the gospel truth. So build that attitude. Because when you have that attitude, I'm not saying be rigid towards learning, no. In advocacy, knowledge is something that will begin in the womb and end in the tomb. But summarizing the facts of the case as an advocate, when you are contending something in the court of law, you are never wrong. Have that approach, that fighter spirit. Muhammad Ali, the boxer, always quotes, float like a butterfly, sting like a bee. Your arguments should make you float and pack a punch. When you are citing, when you are using your law, case laws as an analyst. That should not be your whole and soul of the argument. It should only be that element which stings you. To nail the coffin, to nail the coffin on its head, putting it in a more rhetorical language. So work on that. But one thing that I think my brother judge also agrees with me is the preparation you have put and the maturity you have shown at this age in terms of interpreting the consumer protection or though there are certain things that we disagree with you on the usage of Companies Act and other premise of law for this age, the amount of maturity, the amount of interpretation, without knowing the basics of interpretation of statutes or without knowing the basics of CPC and other statutory and procedural laws, the maturity, the aptitude and the attitude that you guys have shown in conceptualizing these concepts and presenting with so much confidence, I think everyone deserves a huge round of applause. And this applause is dedicated to those faculty members who have trained you and ingrained you in giving you that maturity. So it is highly commendable because at least sir is from a more older school. Like though I come from a modern generation, like at least I'm a decade old. When I have to go back to my days of being a law student, though we had intro moots and all that. My goodness, believe me, like I still remember my internal rounds were similarly, which was hosted for first years and second years, where first years were made to compete with second years. I could not even open Article 14 in the Indian Constitution, let alone delving into other statutes. So I could not even recognize between what is the basic structure doctrine, what does Article 12 to 32 come under, like if these are the fundamental rights. Only thing is because I had done political science arts, I could navigate. But give me a constitution, ask me to open and show me that, sir, this is what it says. Zero. So at this rate, at this speed, not to give you a crown on your head or something, but if you maintain the same tempo, same consistency, as sir said, read newspapers, read online blogs, because this is where we have to become better than the extraordinary. Some of the people in the room who had recently been to an MUN can vouch for the fact that today we are living in a generation where engineering students are ahead of us in legal interpretation.
Yes, sir.
What, Gauda?
Yes, sir.
Yeah. Personal experience they'll tell you. When engineering students can come and stand here and debate, who are in their first years and second years of engineering. And PU students are in today that is the society, that is at that rate the society is transiting and evolving. So there is no room for being like, chalo first year hai, तो lethargically देखेंगे 5 साल है पढ़ने के लिए. You have to confront your demons, you have to confront mediocrity, you have to confront normal way of life. You have to focus on being extraordinary, you have to focus on doing things which is unconventional, you have to have a vision of creating a history, because what has happened has happened. Because with the graduation of your 5th years and 4th years, the corona batch will come to an end. Now the legacy is on your lofty shoulders. With Sir's batch, Veerbhadraya Sir's batch, they set up one example, they set up one legacy. Nalini Ma'am's batch, all these people set up one kind of a legacy. With corona and pandemic and online education, the entire pedagogy is devastated. The entire legacy is devastated, it's distorted now. Now the task is on you guys to reorganize that legacy. So what kind of a culture you want to leave behind in this institution? Now you guys have the battle. So whether you want to leave behind a legacy of being vagabonds, or you want to keep this tagline of being a time pass college to the society, or whether you want to make this as an intellectual hub, where if people across the nation, I'm not just talking about Bangalore or Karnataka or the ambit of KSLU, if they think of B.M.S, they should be like, oh, win or lose, but they send bloody beasts who are ruthless. You want to leave that kind of an attitude, it's now on your shoulders. For which, if your target is 10 miles, aim for the 11th mile, and when you're pedaling on the 7th mile, always think that you're cycling on the 6th mile. So always feel that you're one step shorter, never underestimate your opponent, and always keep your targets high. Always have a vision, and on that note, all the very best, and may the best team win. And thank you so much, Madhukar sir, for the pleasure argument. Thank you, and for giving us this opportunity, and for considering us as the right people to take up this task, and I hope we never let you down. Thank you, sir.
Okay, so
oratory aspects and all. My special thanks to you. I also extend my thanks to Arun sir for taking care of all the technical aspects. Very thankful. I'm sincerely my gratitude to my student coordinators, Jagdish and they are not there they were there as a co-clerk. They were the people who were with us from the beginning, and thanks to you all. And I extend my sincere appreciation to all those 8 teams who took initiative in participating. 32 teams were registered, but I don't know what was the reason. Even today we are unable to know the reason why they withdrew. Yeah, so they were like, when it comes to the submission of memorial, they started withdrawing from the competition, but that's okay. Maybe you have learned now, those who have, that the live streaming is also going on because of this, so they will be, that's okay. There are a lot more to go. This is just the beginning. So I congratulate and I appreciate all of you for putting a lot of effort in making this competition successful. May the best win. Thank you. I would like Priyanka ma'am to announce the results.
Sure.
So, the best memorial is won by TC14. Was a tie between 2 teams and has scored 36 out of 50, and TC6 and TC14. So congratulations. Best speaker male from the preliminary round goes to Vagni. Best speaker female goes to Rishika Gowda. Team B. To announce the winners of the
So even I'm going to give it for you.
Very good evening. So, runners for this competitions goes to TC14. TC06. They are the runners. TC14 is the runners. TC06 is the winners. TC14 they got 214 marks. 214. Winners they got the 235 marks. 235. So congratulations for both winners and runners. Not only for both than those who are participating in this event. For all, congratulations.
Official prize distribution will be on any one of the grand occasions, okay, in the presence of all the other classmates and batchmates, so seniors in front of everybody. Yeah,
And
thank you.
principal.
Yeah, principal, obviously.
Speaker. ಹೊರಡದ